one of the question that comes up often is, what is firstly prior art search? How is it important for startups and MSMEs? And in the workshop, we always, like in our, you'll see later in my slides, where we talk of the various incentives that uh, India government is giving for startups. Under SIPP, for example, we have expedited examination, we have patent, trademark, industrial design facilitators. So we make sure they're aware of those things. Uh, but yet, they're not fully sure of what prior art search is, how significant it is. So today's, session is geared around that problem statement. That how do we demystify this particular topic for startups?
So is this that the most of the participants are well aware of patenting system and all? And what are various benefits that recently amended rules offer to them?
So it'll be great if you can touch upon those again, because it's not the same set of participants that we get always. They may keep changing. There might be someone who's new and they may not be aware of it.
Okay, sure. And one more thing, that whether the participants, any of them are having this prior experience of filing patent or having some IP rights on their name.
Yashpal, maybe if you can comment. From what we have seen in the past, it varies all across the place. There are some folks who have the experience, and we can figure that out from their questions where they ask pinpointed things. But a good number of them may not have even gone to that step. A lot of them are curious. They are in that boat where they want to form a startup. They have an innovative problem, that or at least an idea of how to go about it. Not have even considered IP rights.
Yeah. Okay, great.
Sure. Yashpal, I think just checking. Do we know if Dr.
We'll go
Wilson
live at sharp 3.
Has Dr. Wilson joined the call or
Yes, she's joining in a minute.
Okay, all right.
Hemang, Mr. Gupta, Yashpal, Kirti, SHM team, as we start the conference, I have an interesting, milestone to share with you. We are now at 3,993 registrations. So I think that once we finish the conference, this webinar, we would have crossed 4,000. So maybe, yeah. So Hemang, maybe when you speak, you should just announce this, and I will type both the Play Store link as well as the L2 Pro website link, and you can request participants to webinar participants to register, and it would be great to cross 4,000. And once it crosses 4,000, even if somebody is speaking, I would just like to put that chat out that yes, we have crossed 4,000 registrations.
Will do. Thank you, Anirban. We're very close to 4,000.
Very, very close. I mean, I think it is like, as you know, that we are all interested in cricket. It's like, I mean, it's even better than that 90s because yeah.
I think we should get the Sehwag mode and Chakka Mar.
Yeah, yeah.
Dr. Shah, we are going to live in another 10 seconds. Let's prepare for going live.
Sounds good.
Please go ahead, sir.
Hello, everyone. Thank you for joining us this wonderful afternoon. Our workshop today is on prior art search for startups and MSMEs. On behalf of the ASSOCHAM IPR Council, I welcome you all. Today we have a very interesting speaker lineup. We are joined by Mr. Santosh Kumar Gupta, who is the Assistant Controller of Patents and Design at the India Patent Office in Delhi. We also have Dr. Neeti Wilson, who's a partner at Anand & Anand. Alongside us, we have a team from Qualcomm, my colleague Anirban, myself also in my other hat, and of course our assistant colleagues, Yashpal and Kirti. Before we start, I thought I'd just introduce you briefly to our speakers for today. Mr. Santosh Gupta, he has an amazing expertise. He's an engineer turned quasi-judicial authority and who's working as an assistant controller of patents and designs at the India Patent Office in Delhi. He holds degrees in the field of information technology, software systems, and IPR laws. He also holds a diploma in fostering innovation and commercialization of IPR from the Copenhagen Business School in Denmark, and has also been certified as an innovation manager by DANCERT, which is the Danish Technological Institute. Very impressively, he has been working with the Patent Office for 10 years and delivered 3,000 plus patent applications in the field of computer science and IC.
Doctor, sorry to interrupt. Your voice is cracking. Not able to hear you very well. I don't know if it's the same for everyone. There's a lot of disturbance in your voice.
Oh, is that so? Give me. Yeah, Yashpal, Anirban, can any of you confirm that?
So it's clear from our end. We are not facing any issue.
Hemang, just to say that, I mean, the
No, it's
speaker
not-
who just
It's
kind
not
of
clear.
mentioned
Voice is cracking.
It is cracking. So
a little bit,
give me a minute.
not as clear as other speakers.
Sorry, just give me a minute.
स्क्रीनशॉट कहाँ है देखिए कौन दिया गया है
Can you hear me better?
Yes, this is great.
Yes, sir.
Wonderful.
Yeah.
Just I think there's something up with my audio settings.
Yes, we can hear you, Dr. Wilson. Dr. Santosh, your image is coming a little blurred.
It's a bit blurred. Okay.
Yes, yes.
All right. I'm not sure what's up.
No, Hemang, not at your end. At Mr. Santosh's end, the image is a little blurred. Yeah, that made it very clear. Hemang,
Okay.
I think you. Yeah, now it's clear, Mr. Santosh.
Sure.
Hemang, you
Okay.
can go ahead, please.
Thank you all. Apologies, everyone. Sorry for the technical glitch. Sometimes these things are out of our control. So let me begin from the beginning, which is, just an introduction of the speakers who are joining us today. Mr. Santosh Kumar Gupta is an assistant controller for patents and design at the India Patent Office in Delhi. He is an engineer turned quasi-judicial authority, and he's someone who holds academic degrees in the fields of information technology, software systems, and IPR laws. He holds a diploma in fostering innovation and commercialization of IPR from the Copenhagen Business School, Denmark, and has been certified as an innovation manager by DanCert. Very impressively, he has been working with the patent office for 10 years and has dealt with 3,000 plus patent applications in the field of computer science and ICT. Mr. Gupta has also functioned as a faculty at the Rajiv Gandhi National Institute of Intellectual Property Management, which is RGNIIPM Nagpur, for various batches of the newly recruited officers for Government of India and for public training programs in IPR. I really look forward to his insights today. Welcome, Mr. Gupta. We also have with us Dr. Neeti Wilson, who is a partner at Anand and Anand. Dr. Wilson specializes in IPR management and protection with customized planning as per the client's needs. She also provides IP monetization related strategic advice besides other areas including licensing, management, opposition, revocation, and infringement. She's a lawyer with a PhD in applied sciences. She appears before various legal authorities, including Indian Patents, Designs and Trademark Office, Plant Variety Authority, National Biodiversity Authority, Intellectual Property Appellate Board, and judicial courts in India. She is an active member of various international organizations and is an executive committee member of the India chapter of APAA and also India representative of its emerging IP rights community. She is someone who has a terrific background in IP, in the area of IPR, and again, we look forward to hearing her insights today. Welcome, Dr. Wilson. Yeah. So before we jump into the speakers, I just thought of sharing an outline about today's material, which has been brought by L2 Pro India. L2 Pro stands for Learn to Protect, Secure, and Maximize Your Innovations. It's a completely free IP e-learning program available on the Play Store, App Store, and web. The genesis of L2 Pro started, when, through our programs in working with startups, we realized that the IPR awareness was an area of improvement. And a pain point that we saw was that when we brought IP professionals with the startups and all that, their questions and answers were solved with a great ease. But what happens when startups don't have access to, say, Mr. Gupta or Dr. Wilson here today? Because innovation happens in the everyday life at their offices. And that led to genesis of L2 Pro, which is a program that belongs to DPIT. It's their initiative, and in partnership with NLU Delhi, who is the academic partner, and we provided insights from the startups. L2 Pro enables startup founders, CTOs, MSCs, SMEs, and MSMEs to really understand the benefits of IPR as a business strategy. The course is split across 3 modules. In the basic level, we cover all the IP fundamentals which are relevant to startups and MSMEs. At the intermediate level, we get into further nuances which cover the filing, acquisition of IP, and we'll see some of that importance of that work today. But even greater things such as how do you manage IP portfolios? How do you get to commercialization? And then there is an advanced level which talks about the deeper nuances of intellectual property rights, such as access to funding, how standards and standard setting organizations work, and how can a startup think of dealing with disputes. At the end of each level, there is an assessment, which is a case study assessment. And the case study's purpose is to, again, make sure that it's an example that is relevant to how a startup functions. And more than checking your factual knowledge, it's more like, what will you do if you are in that situation? And because it's meant for startups, the material is also presented in a reference guide format. Right? So you can find information such as, where can you find the different elements of the startup intellectual properties scheme? What are the patent fees available for startups? What the patent trademark facilitators are? It will ask, you different questions as you take the course. It also has introduction and summary videos. So for some of you who joined early, you would have seen the introduction video. It's about 2 minutes of duration. And at the start of every lesson. And at the end of every lesson, you also have a 2-minute video. So in my personal opinion, if you spend 5 minutes, you can learn around 70% of the course material. And for the deeper things, you start getting into the different lesson elements. There's an assessment, as I mentioned, and if you complete it successfully, you get a certificate which is uh, generated on the spot, and this certificate is provided by DPIIT, CPAM, NLU Delhi, and Qualcomm. And just to share an exciting stat from everyone working on L2 Pro, we are at 3,993 users right now. So we'll be very happy if you all can register. We'll share the link for L2 Pro in the chat box where you can download it. Again, it's completely free, lifetime free. It's a reference app. Oh, so my colleague Anirban just shared its 3997 users. So if you can help us cross it, and hopefully L2 Pro will help you in your IP strategy goals. So with that, I'll turn it over to our speakers today. And first, we invite Mr. Santosh Kumar Gupta to share his insights. Over to you, sir.
Thank you, Dr. Saab. And hello to everyone. It's an honor to speak on this particular subject matter. It's a very interesting one because when we talk about startups and MSMEs and their contribution in the Indian employment is phenomenal. And when we talk about their contribution with regard to India's GDP, it is around 30%. So, and the export share, it's around 50%. So that's very phenomenal. But when we talk about their share in the IPR, that's where there are a lot of work that needs to be done. That's where we feel that it's a very important thing where all the startups and the MSMEs, they should live to their potential. India as a country is a very unique country. And here, whatever we have is we cannot have one straight jacketed model that can be imported from any country across the world. It's a very unique socio-economic condition where we need to have Indian contextualization with regard to various solutions to our problems. Our society has various problems that needs to be solved, and with the aim of adding value to the society. When we work, so our startups and MSMEs are doing phenomenal work. But when we talk about whether they are getting proper monetization with regard to that in terms of knowledge economy, we feel there are many things and miles to go. So basic thing is when we talk about IPR, it's not just about filing. When I talk about my experiences as a controller, when I look the applications which have been filed by various MNCs, and when I compare the same applications with regard to which are being filed by the startups and MSMEs, there are certain areas which needs where we have a lot of scope to improve. And as controller, since the act has a lot of things where there are fee rebates, more than around 80% of the fee has been reduced for the startups and the MSMEs, and they have been brought to the equal pedestal like the individuals in terms of fee. We also have certain facilities called expedited examination. So with the expedited examination, it is possible that you can get your patent granted within a year or a couple of years. So that's a very interesting fact because generally most of the people will talk about that, okay, there are certain backlogs and it takes a lot of time in Indian jurisdiction to get patent. However, now after the expedited examination, we come up with the stories, and I have myself have granted one application in within 7 months from its date of filing. So once the publication was done, 6 months was the statutory period when it cannot be granted, and it was granted in the 7th month. So there are a lot of success stories with regard to expedited examination, particularly for the startups and the MSMEs. But where are the pain areas? These are the good areas which I talk. Pain areas are drafting and searching. Two things where it needs to be improved is with regard to drafting and the searching part. When we talk about searching part, that is the topic of the day. But most of the time, the prior art search, since you may be aware that prior art is a very important requirement. Prior art search is a very important requirement because for patentability, we have three criteria: novelty, inventive step, and industrial applicability. Industrial applicability is most of the time proven easily. Where it lacks is with regard to inventive step and novelty. Because whatever filing, whatever your innovation is, that should be of such nature that it should not be anticipated by the prior art. So here comes the importance of prior art search, because when it is from the startups and the MSMEs, we understand that they don't have such type of huge resources like MNCs have, who can go on and search and all those things. But interesting part is that there are certain things which if you follow due diligence, if you follow in your prior art search, it will help you. First thing is that you should break the linguistical barrier. The biggest problem that we feel is the linguistical barrier that comes with regard to searching by keywords. Most of us search by English keywords and the synonyms thereof. But what happens that when you search by keywords and their synonyms, there are a lot of applications, a lot of patent literatures which are not in English. They are filed in, say, Chinese, they are filed in Koreans, and you are unable to capture that. So sufficient focus must be given with regard to searching by a methodology which generally breaks the linguistical barrier. And that is where the classification comes into the picture. There are some concepts called IPC, International Patent Classification. There are concepts called CPC, Cooperative Patent Classifications, where various fields of inventions, various fields are categorized and given a particular symbol. Once you read a little bit about IPC, it's just like you can say alphanumeric word, where it categorizes, like if I give an example, G06F. G06F is particularly broadly for inventions which relate to computer science. Or if I say H04W, it is something where the inventions which relate to communication field. Similarly, A61B, which is for the biomedical. So some type of these type of classifications you have. And when we search on free platforms like, say, Google Scholar, Google Scholar now has this facility that it has CPC associated even with the non-patent literatures. So once you become a little acquainted with the classification concept, then you break the linguistical barrier. What happens that these are the classifications where the documents are grouped. When the documents from various languages are grouped, and you know that, okay, this is my field of invention where I need to search, and you search is by those classifications. So you break that linguistical barrier, and you are easily able to capture particularly the Chinese and the Korean applications. Because it is one of my observation while working as controller that with regard to startup and MSME applications, majority of the time the citations that office cites, it's from non-English language. So it seems that when it was getting filed, that time due diligence with regard to these literatures which are in non-English was not taken care of. So that is something where I feel that it can be improved upon. Second part is with regard to drafting. Drafting, sometimes what happens that we fail to understand the importance of a patent document. A patent specification is a techno-legal document. Many a time either we feel like a legal document, many a time we feel it as a technical document. However, it is a techno-legal document where you are specifying the technical aspect at the same time when you are including your claims. It is the legal protection that you are going to get. So enough due diligence need to be done with regard to claims. Sometimes what happens that claims are drafted in such a fashion that even if the patent is granted, that may not protect sufficiently. So the kind of protection that you need, it requires due diligence with regard to drafting. since here we are talking about mainly we are talking about the searching part. First is that whenever you want to solve some problem, always remember why you have this patenting system. Patenting system wants to prevent everyone from reinventing the wheel type of problem, that someone has invented the wheel and you are again putting all your effort to reinvent that. And when you come up to the office stating that this is my invention and please give me the patent with regard to this, and when office comes across various literatures, whether it is patent literature or non-patent literature, and says that this was something which was existing in the prior art. So even if, as you can say, even if at my personal level I may want that, okay, I want to grant this particular application, but if there are certain prior arts, I cannot, because law doesn't mandate that. So that important aspect of prior art needs to be understood. First thing is that it will, if you don't search it properly, it will impediment your chances of getting patent. At the second, and the second problem is that your effort will be in reinventing the wheel. Something which was known in the prior art, in the public knowledge, just because you were ignorant, it doesn't mean that the whole world was ignorant about that. It was part of that. So these are two important things which I feel that if they are improved upon, we can see a lot of positive change with regard to patentability on the IPR regime of the startups and the MSMEs. And since I've already talked that more than 80% of fee rebate government has given, expedited examination provision is there, a lot of refunding facilitation schemes are there, and you can get a lot of other benefits. However, after getting all the benefits, everything comes that whether you are able to get that IPR or not. So to get that IP right, the patent search is very important. Keyword search is important, no doubt. Keyword search helps you to zero in, okay, what is my field? And then you come up with classification, the IPCs and CPCs. Then you go drill down a little deeper into those aspects, that, okay, what is my invention, how it is. And then comes the drafting part, that how well you draft, what do you need. Sometimes you have a lot of good resources in the free domain also, and you have a lot of other helps with the professional helps also. So but important thing is that once you capture the importance of this prior art search, it enhances your valuation, because now we all know that we are moving towards the knowledge economy. And for if we talk about US economy, more than 50% of its GDP is from the knowledge things, intangible aspects. So considering all these aspects and how, where our strength lies as a country, our strength lies in the startups and the MSMEs, because they are the bread providers. They are the people who are giving more and more and more employments. So I think that today's session we can talk about a lot about the patent searching, since Dr. Wilson will be talking about those points, and I'll be there for any question or anything. So with these words, I would hand it over to Dr. Shah. Thank you.
Thank you, Mr. Gupta, and truly cannot agree with you more that the future of the country is going to be driven by startups and MSMEs. Across variety of fronts, right? We've seen how they've introduced very innovative, novel products. The support from the government on a different scale of things. Like even apart from, let's say, what SIPP is providing, but even things like UPI and how it has made our daily life easy, and how all of us are so technically advanced. Then just compare yourself to how your world was 5 years ago. It's all because of innovations around us. So thank you so much, sir, for sharing those insights. There's a question from Taruna Sharma about, I can't follow, but it says asking about secret prior art search. I'm not sure if there is any. Taruna, maybe if you can, chime in a bit more, give us more context.
Hello, sir. My greetings to everybody. Sir, I wanted to ask, because I am in IPR department in MIT, Ministry of Electronics, and specifically I wanted to ask about those 18 months in which application is not published, and we have filed because secret prior art is something which is not into the publishing and in public domain. So how can we tackle that thing? Because it always acts as an impediment for the searches. So in that context, I was asking.
Okay, thank you. So if I understand correctly, Mr. Gupta, the question really is, there'll be a number of applications and they will not be published, right? Because of this 18-month, blind window as such. Uh, would the patent office also have access to these things if something is not published when you are doing the evaluation?
Yeah, patent office has the access to those things, but the thing is that those thing which has not been published, that will not be cited. We do that, but that will not be cited, because ultimately, see why we are doing this prior art search. Something which is in the public domain, if you have got access to something which is in the public domain, there are chances that you will copy that and you'll project to the office as your own work. So office want to discourage you that no, this is not done. You'll be given a monopoly, your patent rights, just because your own work. And if something has not come in the public domain itself, so that will not be cited. But yes, we do have access to that.
Thank you, sir. I don't think we have any other questions at the moment. So maybe we invite Dr. Wilson, to convey her remarks, and if possible, if we can
Hello.
even see how prior searching is done.
Hello.
Sorry, sir, can you take one more question? Looks like there is some.
Yes, sir. Can you
Please go
can
ahead.
you share can you share which site we supposed to do the prior search? Is it the Indian patent site or Google patent site or where? Which one is the best place to search? Can you
Okay,
show us a demo
sure.
by
See, the
sharing the
thing,
screen?
yeah, sure. See, the thing is that what the law says that anything which is in the public domain and which can anticipate your invention, that can be that will be called a prior art, and your invention will not be granted if that anticipates your invention. So the thing is that law mandates patent literatures as well as non-patent literatures. So you can search on Google, you can search on Google Scholar, you can search on Indian Patent Office website, you can search on USPTO website, you can search on European Patent Office SPASnet, you can search on BIPO's Patent Scope. So there are a lot of engines. The main aim is it with regard to searching, you can never say that this is the best thing. Even the search strategy which is done by, you can say, the best examiner or the best officer that we have in our system, even that person cannot say that this is the best search strategy. Similarly, there cannot be one platform which is the best platform.
Excuse
So
me.
we can use all these platforms, and which all these platforms are good. Google Patent is good, Spasnet is good, WIPO Patent Scope is good. For initial familiarization, in pass is good. Indian Patent Office search engine, that is also good. There are a lot of paid search engines also. But to start with, you can carry out. You can start with Google Patent, Spasnet, and Patent Scope.
Basically, sir, when we design this reaction, so he's supposed to go to the SciFinder and search whether the reaction has been done or not. Basically, for the nobility we used to do in chemistry. Similarly, what I'm asking that if I'm planning a thing that this I am going to prepare, so whether anyone has prepared it or not. So I have searched the non-patent search. I know that PubMed I will go, and some good sites are there where can I comes to know that yes, whether it has been done or not. Similarly, my question is that is there any platform is there where we can type and we can directly get, I don't have to go to eSpaceNet, or I don't have to go to the European Patent Office or Chinese patent search and different. Is there anywhere we can type Google patent? Suppose if I'll type that one, so does I'll get all the things? Is there any keyword is there, or what is that is there you used to do? Because it is a most important thing when you are trying to do a work, whether
Yeah,
it has been done or not, and when anyone has patented on, because when the idea comes, it has to be validated before performing an experiment, perhaps what I'm asking, right? Or else once I will do and at last I will comes to know that someone has done, so it's a wasting of time for me, right? So that is my question. If you can guide, it would be very thankful to you.
okay. See, there are paid databases also and there are free databases also. You can start with Google Patent if you don't want to go to various websites or various things. You can start with Google Patent, which is a free one. Like in Indian Patent Office, we use PATS here, but that is a paid one. So you can start with as a user with the Google Patent. Most of the things it will give. So, but I'm not saying that that is only the best thing. It's just that where you feel most comfortable. Google Patent will give you sufficient results, will give you good idea, provided you search it properly. That's the key. You cannot say
How
that.
to do that one? Can you, sir, how to do that one?
So,
Can you have a,
Ashokji and sir,
yeah.
can I interject? I think Dr. Wilson may actually cover some of that during her session.
Okay, please. That's my request, madam.
Yes.
Please. Yeah.
Uh, Basically, I have a question with respect to the 18 months. So when we have filed an application and it is in 18 months, which is not disclosed, the prior art search. So is the RTA applicable for that? Provided, can I file an RTA saying that, okay, is this invention is already in scrutiny or whatever it is? Is the RTA applicable for that?
That's interesting. But the thing is that with RTI, what you want to achieve, whether you want to know the status of your application, that is available on the IP India website.
No, not status of the application, like whether
Maybe
this.
I can take the question after my presentation because this will clarify, what is prior art.
Yeah, I suggest at this point we transition over to Dr. Wilson, who's going to show us or share insights on how to do prior art searches. Thank you so much, sir, for joining us here today. And let's cover Dr. Wilson, her presentation, and then again we'll break for Q&A.
Thank you, Hemant.
Thank you.
Actually, I prepared a very basic presentation. I did not know what to actually prepare. So I'm starting with what is prior art. And I'll just like to share my PPT if that's okay.
Ma'am, you can do it now.
Yeah, okay, thank you. And anytime you feel that I'm going very fast or very slow, you can always stop me. I'm a lawyer. I can extend and I can shorten anytime. Okay, can you see my screen?
Yes, we can.
Okay, because I cannot see anything else now. All right. So for my presentation, I was told 2 days back, prior art searches, this is what I had in general in mind and I just put it together. So in general, I'd like to start with, when we're talking of prior art searches, we're talking of prior art related to patents. And there are different types of intellectual property. All of them require searches, but we're talking specifically patents. But when we do prior art searches, we are not only doing for getting patents, we are doing prior art for all innovations as well, whether it's creating innovation, putting innovation in market. So we have to think much more broader than patents when we are talking of prior art search. So what is prior art? Prior art is nothing but information which is scientific and technical and which is available to public. So the question of Mr. Arun, is answered here that the prior art, which is not yet published by the patent office, is not accessible to public. It is confidential information. It cannot be taken through RTI. So you cannot. The patent officers have access to it, and they can use it in their search reports, provided that it has become published. They can always say that the publication date was later than the priority date of the application filing, but they cannot put it in public domain till the time it is actually published by the patent office. And this prior art is not just documents, it's also usage. Use of any innovation, any invention is also prior art in terms of when we're talking of innovations and patents. And what distinguishes as to what is already state of art or what is going to come or what is just put it in the public domain is the effective date, the date from which you're actually searching. If you are filing related to patent, if your search is related to patent filing, it is from the date where your application is filed. Any document, any usage prior to date of the filing would be considered as a prior art. And what is a prior art search? Prior art search is nothing but an organized review of all the prior art material, all the scientific and technical material. And the purposes are economic, which is the reason why we are here. And of course, technical and legal, because it will have a lot of implications in it. Now, what is prior art as per legally? Definitions differ from country to country. I have taken out a list and just took a snapshot of several countries where prior art is defined. In India, you can see here that it is publication in any document, or if the invention is used in India or elsewhere in the world before the filing date, which is the priority date. So where you are doing prior art, for what purpose you are doing prior art becomes important. In India, publication is one of the very important criteria. The types of searches, the first search which everybody knows about is patentability search, where you are trying to get a patent and you are going to do this patentability search. This search is done by innovators. This search is done by patent office because they are going to check the patentability of your invention. And this search is mainly for planning of research as well. The second type of search, which is an infringement related search, where you feel that if a third party is producing the same thing which you have patented, whether there is an infringement or not, or the other way around. Validity searches as to when you say that this is going one step ahead, I'm going to license a patent application, whether I'm going to license in or license out, whether my patent is valid or not, to be licensed, to be used. That's what validity searches means. For freedom to operate searches, which Hemang also mentioned, is another important search where you are actually going to market and trying to find out whether you're free to go ahead and use your innovation, market your innovation, sell your innovation. And there are several bifurcations of each and every type of search here. So I'm not going to extreme details. I will not get into the details. Okay. What is the search that you do when it comes to patent search? The patent information comes from very different places. The last one, as you can see, is non-patent information. Somebody mentioned SciFinder here. There's Google Scholar, and there are several scientific publications, PubMed, which you are using for non-patent information. But mainly for patent information, you have different types of patents: utility, plant design patents. Then you have chemical structure searches. And what is the one which I like most is the file histories, which is written here. It's basically the patent prosecution file. Prosecution means from the time of filing till the day it's granted. So this is the patent prosecution file, the complete history where different citations are done by the examiners, the responses are made by the patent applicant, and finally a decision is given for grant or for refusal of the application. That has much more information rather than the final patent application. When we talk typically of patent information, we are talking about published patent applications, we're talking about granted patents, and all the other documents which I mentioned in my patent file history point. Then there is also patent family, because several patents are linked with each other. So for example, suppose you're doing a freedom to operate search and you found a patent and you said, okay, in front of this patent, I have freedom to operate. However, there could be a linked or related patent and the freedom to operate may not be complete. So patent family searches also become important.
Then why should I?
Sorry. Okay. So the patent document itself has a lot of information. I mean, it's wealth of information there, whether it is related to the application numbers or title, because you have to limit your searches. Otherwise, sky is the limit to keep on searching, and you can still never say that I'm 100% sure there's nothing like this. So how you search, where you search, when you're searching patent document also becomes important. And you start with broader searches, maybe the full text search, and then you keep on getting narrower and narrower till the time you reach exactly what you're looking for based on the purpose of your search. I'll not get into the search phase now. This is what most of the time people talk when they talk of prior art search, which is an invention specific search. In this search, where what we are trying to do is finding documents related to either a patent or an invention which you are trying to patent. And this is a search in which you have to keep on searching till the time you find something similar or in the area, so as to find out the distinct differentiating features, if any. And if you find them, then you do the analysis whether it is patentable in terms of novelty, non-obviousness, and utility. So having said this, you know that for patent searching or any prior art search, you need to have the skill set of doing the search. Yes, you can start with doing with your Google Scholar and Google Patent Search, but you need to keep on getting ahead and knowing that, yes, if I am doing an ICT search, do I have a technical qualification to understand where to search, what to search, whether I'm doing a biotechnological search, whether I'm doing a chemical structure search. You need to have the technical qualification and that eye for detail to actually take out what you're looking for. The different strategies based on the objective. And as Dr. Gupta also mentioned, the keywords are the most important thing, because ultimately you would be searching with the keywords, whether you're searching in paid database or non-paid databases. So defining keywords is the crux of your search strategy. And various fields can be used for searching. Somebody asked where to search. So there are public databases available, also mentioned eSpaceNet from EPO. There's WIPO has Patent Scope, USPTO, Patent Abstracts in Japan. ICSPA is the Indian patent database. Now we already have everything within the Patent Office website in PASS, so ICSPA may not be that required. But yes, the time when Patent Office, all the data was not available online, that time it was a very good source. And IMPADOC, of course. There are several paid databases which you can search in your specific area of where you want to search. And these will do some analysis also. So these paid databases will have much more information and much more, they will be much more helpful, but of course you have to pay for it. I'm not quite into these databases specifically. Online searches, as I said, can be a good starting point. I leave it as a blank space, because when you're doing your first search, you're trying to find out, first defining your purpose and then doing an online search what you can find relevant. But you have to narrow down. Okay, there are different types of analysis and information that you get. I'm so sorry. Okay, this is old one. Now, what I wanted to say here is that when you are doing your searches, the first important thing is that which IP that you're looking at. Whether you're looking at patenting a IP, whether you're looking at taking an innovation in a manner in which you can need to license an IP to actually take your innovation further in market, and whether you're actually trying to sell your IP, which you have already created. This all IP management need to be synchronized together, so that in total you can do the search. I can go online right now and do a search with you all if you require. However, I believe that doing patent searches itself requires an altogether different session, where you take in that, okay, this is what we are going to search together. These are the keywords, because formulating keywords itself takes maximum amount of time. And we can have a case study where we can take over that how it is done. So I think I have completed my 15 minutes. Yeah, so I'll stop here.
Dr. Wilson.
Okay.
I'm just scrolling up in the chat box. There were a couple of questions. So I'll pick in the reverse order, which I can see. Purnima Chandran asked a question, which is, if there are any free databases to look for pharma litigation especially in US and EP jurisdictions?
See, the databases of all the patent offices are free. And when you're looking at specifically at pharma patents, then again, what you're talking about is structure-based searches, then non-patent searches are available. There are certain parts which are free, certain parts not free. For example, in PubMed or STN, if you go, there'll be certain parts which would be free already. So you can always use that free part and then get into narrowing your search, getting into the paid part. But yeah, if you get into a specific technical field, you will need to have even our TKDL, the Traditional Knowledge Digital Library. There's a certain part which is free. After that, it is not available to public. So even we are protecting our data. The databases, we just cannot say that why it is paid, because it has value. And no, we are not talking about other IP rights right now, but the creation of database and the way it is being presented and the way the results are shown, they're all intellectual property in itself. So we need to be sure that why we are doing pharma litigation. If you're thinking of litigation, you're already thinking of doing spending some money, and spending money in the foundation of doing your proper prior art search makes a lot of sense.
Sure. There's a question. I'll open it to either you or Mr. Gupta. The question is on, I guess I would call it probably ancient knowledge, which is how do we patent yantras, which are Navgraha yantras or the Shri yantra used by astrologers.
Dr. Gupta, you will take the question.
You take first. I'll
Okay. Okay. Well, under the Indian Patent Act or all over the world, the criteria of patentability is new, novel all over the world, globally novel. So even if you take those yantras which are Rishi Munis created and take it to other countries and try to patent it, there will be no patent granted unless the patent examiner there searches it and finds that there's nothing like that in documentary proof. Our case, which happened in case of turmeric's wound healing properties, is an excellent example of similar thing, where the wound healing property was patented in USPTO because the USPTO examiners did not get any citation or any documents in their prior art search. And in India, if they would have tried to patent, our Indian examiners would have said that this is usage. No, there is no need to get a prior art search. You can just search it on any Google thing or any Indian document and you will find it. However, because it was USPTO, we had to prove it and give it and show that there's an evidence that it is prior art. And that's how the project of TKDL came into picture. So the Traditional Knowledge Digital Library, though the Indian Patent Office has a specific section 3P, which does not allow patenting of traditional knowledge per se. Your innovation related to the yantras would be automatically rejected in the 3P itself. However, according to me, that is not required at all because it does not qualify for a patent under the criteria of novelty itself.
Yeah, and to add to that, one thing we need to understand is that patents are granted for inventions, not for discoveries. So whatever you are coming up with, that should be an invention. You cannot come up with something and you can say that it is novel and I have discovered this. So that should not be the case.
I know all these things. Okay. The reason why I put up this question is that in the month of March 2022, Sri Yantra was granted a patent. The title of this invention is, just give me a second. A device with Yantra having a embedded gem. And if you want, I can give you the application number and the patent number and the name of the patent controller and the examiner. So my question is that when everything is evident that the subject matter in itself is not patentable, then even after examination and the hearing, why was this patent granted?
See, the thing is that right now I won't be able to answer that why was this patent granted. But of course, if this is the case, just by merely what you talked about the title, if that is the case, then should have been some, you can say, post-grant opposition should have been filed, or even at the pre-grant opposition should have been filed. So see, all these systems that just for this thing that no system can claim to be the perfect system, be it any system, even if
See,
it is
definitely the scope of flaws and deficiencies are always there in every system. But my
yeah.
question is that a basic examiner, even a examiner who's a new in a job,
Mhm.
knows that okay, it is a part of a traditional knowledge, or it can be a part of the traditional knowledge. And
Mhm.
even in the examination report, these things were not cited. The objections were only on the claim matter, okay, and there was some prior art which are available in the astrology domain, which is in the USA jurisdiction. So traditional knowledge, TKDL, those areas were never touched in the examination report itself. And what the examiner did was that through his hearing and through his can say conversation with the patent agent and the applicant, they converted that application's independent claim from a abstract nature to a concrete nature with some restrictions. So in a way, it was transferred from being an abstract device having some ancient knowledge elements to a device or a system which is there in a physical world, which can be used in a mechanical device, and which have a use in the industry. So that is what is done, and how he was able to grant it.
May I no address this? Rohit, what I find what you are saying is that the examiner didn't do this, the examiner didn't do that. The point is the examiner did his prior art search. He had his databases from which he had to search. When I started my presentation, the first thing I said that no matter if you search for 10 years on one topic, you can still not be 100% sure that you have completed your prior art search. In case of patentability search, when we do this prior art search, we are trying to distinguish the novelty from what is already existing. Even section 3p, though that says that traditional knowledge cannot be patented, it allows for any improvement to be patented over it. So even a slight improvement or slight change has happened in the traditional knowledge that can become a patentable subject matter, provided you are able to fulfill all the other criteria. It should be an invention which is not just new because you have made that change. No matter how small a change is. I mean, simplicity is no bar to non-patentability. You can patent anything. You take a wire and you turn it and you make it a U pin. You take a wire and you turn it and you make it a clip pin. You take a wire and you turn it and you make it a safety pin. They are all wires. So these small pins still become innovations, and any improvement over the traditional knowledge becomes innovation. The reason why there are possibilities of filing revocation application till the last date of a patent is this, that in case a patent is granted where the prior art existed, what was not known to the examiner who worked on it and granted it, any third party who is aggrieved by this particular problem that this patent should not have been granted can go ahead and file a revocation for that patent application. In fact, related to traditional knowledge, you can approach several government bodies in India, including CSIR, who take this activity to oppose and to revoke patents which are granted wrongly. So, do not analyze one by one each patent. However, look at it the bigger picture. And this, your example becomes a classic example of importance of prior art search.
At the same time, Mr. Rohit, I would suggest that if you'll go with the the Indian Patent Act, you'll see that the pre-grant opposition and the post-grant oppositions, as well as the revocations, there the grounds are far, far bigger than what are the grounds where the patent office can reject, particularly to include this prior uses part also. A lot of things that maybe say obvious to me, but that may not be obvious to you. How a system can distinguish that. That is why it has a very concrete thing where in section 13 it talks about what needs to be searched.
No, but the basic question is like in order to get a patent done, you should be novel, and the basic criteria. I think the industrial application is not satisfying, and then how can the patent be granted just on the basis of some traditional or whatever? Because what can I see from the Rohit's whatever the his contention is, like I can see that the basic the industrial application is not applicable for that, that whatever the astrology or whatever it is, even then the patent can be granted.
See, Arun, what happens that when you look into the industrial applicability, there are a lot of other dimensions also. Since we are not looking at a specific case, we may not comment on that, but there may be a scenario where someone can say that I have a mechanism through which it is getting operated. Though you prima facie you can look as and say that it is like a Sri Yantra or like something, but we may not know what exactly the thing that is getting patented. At the same time, when you talk about industrial applicability is looked into from a very broader picture. When we interpret it, industrial applicabilities, there are certain things like one example we always talk about is photocopier machine. When photocopier machine was patented, it was for the next 12 years. There was nothing came out of that invention. There are certain invention where you can talk about that, look, it is not industrially applicable. But what our act says, it says that it should be capable of industrial applicability. We look into that aspect, that whether it is capable of industrial applicability. It may not be today, with the today's technology, it may not be possible to be industry applicable right on day one. However, tomorrow it may be capable of industrial applicability. So we look into that aspect also.
Yeah, thank you, sir. Uh, let's move on to a different question. Hari Prasad Lakshmanan asks, and this is a database related question. So, what is the difference between STN search databases and other paid database?
STN is specifically for chemical searches. So that's a very specialized database. And other paid databases will again depend on which database you're talking about. So it will be like there are certain databases which are only talking about Indian patents. There are databases which cover global patents in particular areas. I mean, now that we're talking about searches, that also suggests that you can check who is providing patent searches, and several organizations provide free patent searches. For example, CDAC, I know they provide free patent searches in the area of ICT. So there are several organizations and companies which provide free patent searches also. And of course, the main difference between each database is equivalent to any other database that you search. Now, what is the difference? It's like asking what's the difference between Google, Yahoo. No, that's both are search databases, but both have their own qualities. You know, the Microsoft search and the Google search and the Yahoo search, they will all be different search. Some would be specialized. So when you do a YouTube search, it will only give videos. That's how.
So, madam, I have a question over there. Is there any difference? Is there any possibility where I won't get the search in the free search, but is there any possibility that that search will be available in the paid database?
Always, always, not just paid, otherwise also.
So
See,
then,
when I when I began, the first thing I said is there's never 100% sure search report. There is always a possibility that something will come up, maybe a Russian document which was never translated the day you searched. So the search which you do is to the best of your capability, and you have to find the people who do the best searches. Basically, when you're going for patenting, you need to find the searches which are done by the patent offices. The patent officers in India, the number of patent examiners here, sir, correct me, 700? Currently, sorry, sir?
It's 673.
673, around 700 examiners. The searches they do, and in European Patent Office, where the number of examiners is more than 3,000, the searches they do will be very different. You will have to know where you're going to do the search, for what purpose you're going to do the search, and accordingly your search comes out, your search report comes out. The reason why the third party requirements are there, that no one person can do the same search. Till the time we have AI doing the patent searches for us, we'll have to rely on the person who's actually sitting and doing the searches.
And one more thing I would like to add is that when you talk about paid databases, all the organizations which give you paid databases, they do certain value additions. Patent offices, they give their data for free, and a lot of patent offices have their search engines also, public search engines. But still, they also go for the paid database searches or the paid search engines, because they do value additions. Like Thomson Reuters, they have Derwent index concept that they'll do the value addition. We have in our patshare also, we have a lot of other analysis also through which, because patent searching is not a linear job. It is something which can go in a lot of directions. So a lot of value additions, a lot of things. STN provides the structure search and all. So everyone has got its own merit and its own pros and cons. So it's a call that the user needs to take.
Okay, thanks.
Thank you. There's an interesting question from Vishal Sanghvi, who has an experience with IoT products, but he seems to be also curious about Indian craft products. So his odd question is, can we protect? Well, he wants to, I guess, make Indian craft products smart with IoT and other electronics and all that. So you get essentially smart Indian craft products. Can that be protected? I'm assuming patents are what he'll apply for, but Vishal, feel free to add further details if you can unmute yourself.
Dr. Gupta, you'll take this question.
Yeah.
Okay.
The thing is, when you are saying that making the Indian craft smart, what smartness means?
Hello, can you hear me?
Yeah.
Yes. So as we see about the, we have the camera in our mobile phones, and we have the camera in the CCTV. So we decided, okay, let us make Indian simply new items. So like smart nameplates, smart frames. People are crafting the frames, different ghost statue. So we insert our PCB, camera lens and sensors inside. So whatever the smart camera functionality is offered, which is normally produced import from the China or other countries. So such kind of similar functionality we add with our Indian craft item, So such kind of the value we want to add. So my question was there, like if we make such kind of item with a different craft item, so whether it's required separate registration application for all the items, or similar purpose one application is enough.
See, Mr. Vishal, what we get patent for? You get patent for technological advancement, technological innovations. So whether you are making multiple technological innovation, like I can have my camera, I cannot say that I want one patent for taking picture of a tree, and later on I can say that this camera for taking a picture of shoes. Ultimately, the technological innovation, the technological advancement will be in the camera itself. So what is important is that different at the initial level itself, different types of IP we skipped because we thought that that we need to focus on the patent and this part, or we have different type of IP just to address this particular concept. When we go to copyright, when you talk to some community level rights, you go to geographical indications. But when you are coming for patent, the important thing is technological innovation. Where is the technical advancement? And when you are talking about the smartness ultimately will be dealt with that whether your invention as a whole is having certain technical effect. We generally call it that it should be a technical solution to a technical problem through certain technological advancement.
Yeah, so if you give me the 1 minute time, so normally whatever challenge is right now in a smart camera, because it's required the Wi-Fi, either LAN connection or Wi-Fi connection. So we develop some PCB which is cannot require the Wi-Fi connection. It's create this on hotspot kind of a special hotspot And so something new value additions we have done, which is not available till now with any products in the market. So such kind of things is possible to apply as a IP, because such kind of IP we also again come in time to put into the public surveillance area, because the smart cities there is a big challenge about the surveillance implementation. So we come up with this special PCB where it doesn't require the any kind of Wi-Fi and distance of 150 meters. Any police can access the video of the camera. So something new function, little bit changes we have done in the PCB, which is first times. So whether it's such kind of application, whether go for the IP protection required, so it can add more value to the investor, because finally we develop the solution and we require a lot of investment to production of the hardware. Either it used for the heritage purpose or it's used for the public surveillance in a smart cities or other area or individual people.
See, the thing is that if your invention, whatever you are saying, because it's a very prima facie thing, an invention cannot be explained in a minute or two or a 5 minutes.
Yes,
so a brief answer to this would be that if your invention is novel and inventive over the prior art in a technical manner, and it leads to certain technical effects, then it can be patented.
Okay, sir. Thank you.
Thank you so much. I'm scrolling through the chat box and I think we've covered all.
Can I ask a question, sir?
Sure.
Yes, sir. Yeah, this is for the Madam Neeti Wilson. Madam, can you please show us the search, how to do that one? Prior art search, because to have the nobility, it's most important thing, right? Whatever you will do discussion, that is fantastic for our knowledge, but really we are lacking in that, because I think that's why I have joined this webinar. Can you please help in that? It's my wish.
Yeah. So when you do a prior art search, as I said, the first thing that I need to identify is why you're doing the search. What I understand from your question is you are trying to find whether your invention is patentable or not. Correct?
Actually, I want to know that whether, that novelty is there or not. Someone is done already, or what is my new thing, what I'm doing, right?
Correct.
What I'm presuming whether it is new.
So the purpose of your prior art search is firstly defined. Your first action is done. That this is my invention and I want to find whether this is new or not, so that it is patentable. So it will be compatible or not. So once that is defined, then what you need to do is first write your invention in a manner where you clearly describe the novel feature of your invention. Till the time you do that, you will not be able to formulate the keywords for your search. So first you write down about your invention. For taking the example of, say, Indian handicraft products, as was mentioned by Vishal, he knows that his area of invention is Indian handicrafts. That's the broad area. And then you get into what actual the invention is about. This is, for example, say it is related to photo frames. So the closer area becomes photo frames, which is antique in nature or which is more traditional in nature. Now, then you find what is the innovative part of it, which you're trying to patent. What is the difference with what was already there? Suppose the way it is hanged is made in such a manner, I'm just giving, out of my mind, that you have used a different type of, it was an Indian handicraft made of metal, say Bastar art, and you have added in a feature in which there is a new metal which is added in the corner to hang that photo frame. And this metal, the way it is being molded into the Indian handicraft was not known, and it was very difficult to hang it earlier. You could only keep it. So now you have defined that what is the innovative part of my invention. My innovative part is the hanging holding, which is going to get into that iron photo frame, which was made in the Indian handicraft style. Now, once I've defined that, then I formulate my keywords. Now, the broadest area which I could search is, I would say that photo frame hanger. Then you go narrower, photo frame hanger for metal photo frames. Then you go even more closer as to the material which you have used, or the method, maybe some chemical reaction you did for the metal to attach with your hanger. and then you attached it together. So all of these, once you make your prior art keywords, formulate your keywords. I think I'm also answering Webhub's, not Webhub's. Somebody's asked how to formulate keywords. That person's question. That this is how you narrow down, put your keywords together, and then you go to the patent database where you want to search. Now, again comes the purpose. Your purpose was patenting. Was your patenting to be done in India, or were you looking at something else? If you're looking in India, then you can always start with Indian patent database. We have an excellent database in PAS. There was very difficult to search 20 years back Indian patent database. Now it's very easy to search. You put your keywords, you can search through claims, you can search through abstract, you can search through title. Once you see this, you can go ahead and search in other databases as well. Once you search, the results will come. If there are, say, 500 hits which come with photo frame, if you have used the keyword, you will add photo frame along with a handle or a hanger or a hanging hook. There are several keywords which you will formulate based on your technical field. What is your innovative field? And this example is completely, the way keywords are being formulated here is completely different from way keywords would be formulated, say, in a chemical application, in an ICT application, because that's how you will go. And once that is done, once you go to the database, the searches are very easy. You have to just enter the keyword and they give you the results. But that also will take time and effort to do it. And I don't think we have the time to go to a database and actually do a search.
Hello.
So that search, now maybe this can be taken as a project. Please do a search, a prior art search on photo frames with different types of hooks. You'll be surprised to know how many they are, because there are so many things which you can find out whenever you think of innovation.
Hello, madam. Yesterday I tried that I went to the database and I tried to search, but there are a lot more title, introduction, surname, name, date, year, thousands of things are there, right? So I go to the title and try to search the keyword. Okay, suppose you know that in market there is levofloxacin, right? A drug is there. Suppose I have made a derivative and it's also working. I have done some methylation or chlorination or halogenation, any kind of derivative. I have prepared that one. So that is also new molecule, because derivatization is also one kind of product, new product. So I want to do the structure search as well as I want to do the keyword search. How to do that one? It will take hardly 5 minutes, madam, for you to share the screen and show me in your
See,
patent.
firstly, Indian Patent Office does not allow you to do a structure search. So that cannot be done at the Indian Patent Office website. Yes, keyword search can be done. I can just show
And
you.
structure search, where could we do in the free site? Can you guide us?
I'm sorry.
Structure search, in which site
Oh, you
can
want
we
a
do?
session? I mean, there's a whole session on STN searches itself. You can ask Dr. Gupta also. Even patent office examiners have to go through the training to go through do the structure search. And once you know it, I did long time back myself. Now I ask people to do for me.
Mr. Ashok, I
That
think
structure
कर
search
देंगे.
is not difficult at all.
Yeah,
Only thing is
it
you
will take
need to
hardly
know
5 minutes,
which
please.
keywords. Um, I can show you a keyword search at InPass, but I don't think, because I have not got the
Yeah,
password.
Gupta sir will show us. Gupta sir, please show us. The
Mr.
structures are
Ashok,
after, madam, please. It will take 5 minutes.
Mr.
Myself, thank you.
Ashok, Mr. Ashok, see, the thing is that the structure search is done on STN, and that is something when we talk about the search session itself takes a lot of time. Instead of saying that it will take hardly 5 minutes and searching, and keyword search can be shown here. But
Yes.
see, with regard to STN, what happens that even the STN licenses are with regard to IP addresses. Since I am controller of patents, I don't have that enabled on my IP.
It is paid one, you mean to say, right?
It is paid, and it is paid as per the IP addresses.
Okay, okay. So it's not feasible for us to search, right?
That's what I said, that if I have to search, I
Okay.
have to gain access from my department.
No,
Who
no,
is
Exactly.
no,
doing the search? I
no,
will
no.
block a
It
time
won't
to
be
be
useful
the
for
search.
us. Then it won't be useful.
Exactly. The STN search, the issue with STN search is that whenever we need to show, if I need to show you, I'll have to get it enabled on my IP. on my
Yeah,
system's
okay,
IP address.
okay. Please
So
please
that is
show
where
the
the
theory
issue is.
part.
Also, search if you want to learn how to do an STN search, you can just do it. There are several YouTube videos and all how to do STN
Yes,
searches, which only give the but they will only give the basic information. Ultimately,
exactly.
when you have to use STN, because the time counts every every second they count and they ask you to pay for it. So
Yeah.
when you do the searches, you have to first be ready with your keywords, you have to be ready with your structures, what you're going to upload, what you're going to search, and then accordingly you sit down and you just because they have their own language also, so you have to know their language as well. It's highly specialized search, and if you really need to do that search, you can always approach. I think CSI Niscare provides search results, and their database includes STN searches as well. So maybe you can check with them, Niscare, under CSIR. They can help you with that.
Hemang, do we have
Yes,
time for
speakers.
some questions?
That's exactly what I was going to ask our speakers, that we are 15 minutes past our scheduled end time. Uh, can you hang around for a bit more time? I understand if you have other commitments, but
Yeah.
I'll have to leave.
yeah.
Yeah, same here.
So
So
no, indeed.
apologies.
So thank you so much. Like, you were wonderful, and actually thanks to all the participants, right? If you take a look at the chat box, it has been active from the beginning itself. So truly, it was very informative and very patient and clear explanations given by both of you. So thank you, Santoshji. Thank you, Dr. Wilson. Really appreciate it. Thanks to all the participants who stayed on for this long. I mean, these days, seriously, we have webinar overload, right? And this could have been just one of those any other webinar. But if you look at the participants also, the strength has stayed consistent even after we went past our end time. So they were fully engaged, and thanks to all of you. Uh, to all our participants, L2 Pro course material does cover aspects which are relevant for startups. Now, the course material has been written for someone who will not, be practicing as an IP professional, right? It's meant for, let's say, startup founder or CTO whose primary job is something else, but if they want to do some quick things, so you can take a look at lesson 5 on how you can do, let's say, patent searches on your own, but very brief ones. If you go to the advanced territory, like the last few questions that we received, it will not be the right source, right? You have to look at some other coaching material, or like YouTube videos, as Dr. Wilson was sharing. But it's a very free, easy material for you all to get started with, and try it out, and then you can go to the deeper end of the swimming pool. So with that, I thank all the speakers again. Thank you, Dr. Wilson. Thank you, Santoshji. Thank my colleague Anirban, who was wonderfully sharing all the stats. And I just noticed 4,000 learners on L2 Pro. So
Yeah.
thanks to all of them. And thank you to the AstroChamp team for a wonderful job as always. Uh,
Yeah.
See you all later. Thank you for joining us today.
Thank you.
Thanks all.
So